All right, are you Charles W. Pennington there at the jail?
Yes, Your Honor.
All right, this is case number 23 CR 74, State of Ohio versus Charles W. Pennington. Mr. Pennington, you've been bound over to the grand jury of this county by Municipal Court of Hillsborough, looks like. No, the Highland County Court, Greenfield, I'm sorry. And it alleges that you have committed the offense of rape, a first-degree felony. Now, what that means is that you have to be held until the grand jury meets to hear your case. And they have not yet done that, but they are scheduled to meet today. I don't know if your case is on the schedule or not, because those proceedings are not public. However, the law does not require or cannot require somebody to appear before the court to answer to a felony charge until there's been a grand jury indictment. And so that hasn't yet happened yet. And so we're here today at the request of the parties to consider whether you wish to go forward on a bill of information. Now, before we do that, the record should reflect that Mr. King is appearing on behalf of the state and Mr. Armentrout is appearing on behalf of the defense. Mr. Armentrout, were you employed or
no, Your Honor. I would have to be reappointed by the court. We actually started working trying to resolve this matter the day after the bind-over, which was on April 17.
All right.
I don't believe his financial situation has changed, but the court can inquire of that.
All right. Well, we'll need to have him fill out another financial disclosure form. Mr. Pennington, have you had any change in your financial circumstances since Mr. Armentrout was appointed to represent you in the county court?
No, Your Honor.
All right. Well, Deputy, if you would have him fill out a financial disclosure form there, please. After we're done, and then I'll go ahead and appoint Mr. Armentrout to represent you. Let's see. That bind over was April
13.
Okay, looks like April 17th is when the order was issued, but.
I think April 17th, Your Honor.
Oh, okay.
That's correct. Yeah.
Let's see. Yeah, April 17th. Yeah. All right. I'll make it effective April 17th. All right. Now, Mr. Armentrout, you and your client both in agreement that this matter to be conducted today by Zoom rather than an in-person appearance before the court?
Yes, Your Honor.
And that's all right with you, Mr. Pennington?
Yes, Your Honor.
All right. Now, since you're not sitting in court with your attorney next to you, if you need to ask him any questions at any time during his proceeding or talk with him about any matter regarding the proceedings, you just tell me and I can put the two of you into what's called a breakout room. It'll be just you and him on the screen, and no one else on the computer hearing will be able to hear you or see you, and the deputy will step out of the room while that conference is taking place so it can be confidential, okay?
Yes, Your Honor.
All right, so Mr. Pennington, as I said, there's not been an indictment against you yet. Now, in order to require somebody to come before the court, the grand jury of the county has to return an indictment. The grand jury consists of 9 people that live in Highland County that are appointed or chosen to serve on the grand jury. And in this county, they serve for a quarter, meet once each month as usually. And they review allegations of alleged crimes in this county. Grand jury does not make a decision as to whether somebody is guilty or not guilty. They simply decide whether there's sufficient evidence to warrant the case coming before the court and requiring the defendant to answer to the charge. And so only 7 of those 9 have to vote to return a bill of indictment. And once that happens, then you're served and you're brought before the court for an arraignment. Now, that hasn't happened, as I indicated. However, under the law, a person may waive their right to have their case heard by the grand jury and instead agree to proceed by a bill of information. Now, a bill of information and an indictment are basically the same. They are the document that sets forth what the charge is against that person. The difference is a bill of indictment has been voted on by the grand jury, and at least 7 people voted to indict, and it's signed by the prosecutor and the foreperson of the grand jury. Whereas the bill of information is simply signed by the prosecutor or assistant prosecutor stating this is the charge and that you agree to be prosecuted by that. And this bill of information that I have in front of me has your name and case number, and it says that on or about the period of June 1, 2022, continuing through April 13, 2023 in Highland County, Ohio, that you, being 18 years of age or older, did knowingly engage in sexual conduct with V, the initial V, who was not your spouse, and that you knew that V was 13 years of age or older but less than 16 years of age, to wit 14 years of age, or being reckless in that regard. Violation of section 2907.04A, unlawful sexual conduct with a minor, or felony in the 4th degree against the peace and dignity of the state of Ohio. So that's the proposed charge. Now, before we go any further, Mr. King, was the victim of, alleged victim of this offense, or their representative, notified of the time, place, purpose of today's hearing?
Yes, Your Honor. The state has notified the victim's mother and discussed this with her. She indicated that she would not be present for this hearing this morning.
Okay. And you did consult with her, confer with her about the proceedings and what would happen?
Yes, sir, Your Honor.
All right, and she was in agreement with this disposition?
That's correct.
Okay. All right. So that, and did you get this bill of information yesterday, Mr. Armentrout?
No, actually, Your Honor, I think we've had it for a period of time. It looks like we signed the waiver back on May 23rd.
Oh, okay, yeah, I see you did. All right. Okay. So, the document that I have in front of me then is what's called a waiver of prosecution by indictment. It has your name and case number, and it says that I, Charles W. Pennington, having been informed by the court of all my constitutional rights, my right to be prosecuted by way of indictment, and being represented by William Armentrout, attorney at law, Hillsborough, Ohio, do hereby freely and voluntarily waive prosecution by indictment, agree to proceed in this manner by bill of information. Dated 5/23/23, I see Mr. Armentrout's signature. And is that your signature? I'm going to hold this up to the camera. Is that your signature right below the date there?
Yes, Your Honor.
All right, and there's the waiver, and you recognize that document?
Yes, Your Honor.
All right. Now, when you signed this, did you understand that it's an agreement to waive your right to have your case presented to the grand jury and instead be prosecuted strictly on the bill of information that I just read to you that's signed by the prosecutor?
Yes, Your Honor.
All right. Now, the next step in the proceeding then, Mr. Pennington, is would usually be called an arraignment, but we have a plea of guilty form, which is what usually happens when we have these situations. And this document is a plea of guilty. It's 3 pages long. I'm going to hold up the document first to the camera and ask you if you recognize that first page there.
Yes, Your Honor.
All right. On page 3, near the top of the page, there's a sentence that says, I enter this plea voluntarily, and right below that's a line for signature defendant, and that appears to be Charles Pennington's signature there. I'm going to hold that up and see. Is that
Yes, Your Honor.
your signature?
Yes, Your Honor.
And did you sign this on the 23rd of May as well?
Yes, Your Honor.
And when you signed it, did you understand that it was an agreement to plead guilty, which means there wouldn't be any trial, any pre-trial proceedings, motions, etc., that instead there would just be a sentencing hearing?
Yes, sir.
And did you have enough time to fully consider this matter before making this decision?
Yes, sir.
All right, well, it's been 2 weeks since that was signed, and so you've had some time to reflect upon that. Do you feel that this is still what you want to do today?
Yeah, can I have a word with my lawyer just for a second?
Sure. I'm going to put create a breakout room here, and it's going to come up on the screen and says join breakout, and you click on that. And then when it's done, you'll click leave the breakout room, then you'll have to log back in and just rejoin the meeting.
All right, Your Honor.
All right, that should pop up on the screen here momentarily. Okay. Okay, we're back on record.
Your Honor.
Mr.
Remember, Your
Armstrong?
Honor? Yeah, what his question was, I'll go ahead and mention now that on this agreed sentence, there would be a recommended prison term. His question was that he's doing some misdemeanor time now on a DUI, but those days would run with the sentence if imposed by the court. Is that correct?
I believe so for a misdemeanor, yeah. There are some exceptions, and I'm not, what is he in for right now?
Aggravated menacing. It has to do with this case.
Well, I'm not sure about that. I can't answer that question because there are some exceptions under the statute, and I can't recall which those are. I did look at it the other day because we had this issue come up in another case, and that case was one where it was going to be concurrent, but it's in the statute. I mean, if you don't want to do this and check on it, that's fine. We can, just adjourn until you have a chance to do that and, do this later. Although he's apparently on the schedule today.
Yeah, this case is going to be presented to the grand jury if we don't do this now.
Well, you heard that, Charles. I mean, I guess there are some exceptions where it would not run. Were you given 180 days on that charge?
Yeah, 180 days suspended.
Suspended?
Yeah.
They were suspended?
Oh, well, if it's suspended, then you're not serving it. Then it's like you're on probation.
Right, but what I'm saying is when I get out of prison, and I'll come right back out and start doing probation.
Yeah, you might. Yeah, I mean, you're not serving time. Yeah, then definitely, if you got out of prison and the judge in the misdemeanor case decided that you should serve the time, then.
But it was all the same case, is what I'm saying.
Okay, well, I can't answer that question. I mean, if you want to look into that, research that further, you can do that. You and your attorney can talk about that. That's something you should have brought up with the attorney before today.
I did.
He has, Your Honor. He has.
Okay.
It's my position that it did run concurrently.
All right, so you want to go forward or you want to wait, Mr. Pennington? It's up to you.
Let's go forward.
Pardon me?
Yeah, let's go forward.
Okay. Now, the agreement I'm noticing on this form, it says that you're going to enter a plea of guilty to unlawful sexual conduct with a minor under 290704A. It says it's a 4th-degree felony, but isn't this a 3rd-degree felony?
No, that's an F4, Your Honor.
Check to make sure. All right, it's an F3 if a person was 10 years or more older than the other person.
Right, that language is not included in the bill of information. So that's why it's an F4.
Gotcha. All right. All right. So this form then says you're going to plead guilty to the charge, and that the maximum sentence for that is 18 months, minimum is 6. There's a fine available of $5,000 as well, and then also it requires the designation as a Tier 2 sex offender, child victim offender registrant, which would require you to be registered as a sex offender for a period of 25 years. Now, you understand that?
Yes, Your Honor.
Are you facing any felony charges in any other jurisdiction?
No, Your Honor.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, Your Honor.
Now, under the law, if you plead guilty and are sentenced to prison on this offense, once you get out of prison, it'll be mandatory that you be put under 5 years of post-release control supervision by a parole officer under the term set by the parole authority. And if they determine during that period of time that you have failed to comply, then they can return you to prison even though you served the entire term as ordered by the court, for an additional period of up to 9 months for any one violation, up to a maximum of half of your prison term for all violations. However, if you commit a new felony, then in addition to whatever sentence the judge in a new felony case can impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively to the sentence in the new case. Do you understand that?
Yes, Your Honor.
Now, under the law, it's not mandatory that you be in prison for this offense. You could be put under what's called community control or non-prison sanctions, meaning instead of going to prison, you'd be put under the supervision of a probation officer for a period of up to 5 years on a term set by the court. If during that period of time the probation department felt that you were not compliant, they would file a written allegation of that with the court. There would be a hearing. You would be entitled to have an attorney. And if the outcome of that hearing was that you'd failed to comply, then at that time the court could revoke your community control and then sentence you to 18 months and fine you $5,000. Do you understand that?
Yes, Your Honor.
All right, now, I read the charge to you a few minutes ago. And do you understand what it is you've been charged with by the state in the Bill of Information, what, when, where, and how they allege that you did the offense?
Yes, Your Honor.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible offenses you might try to raise at trial, and possible outcome of the trial with your attorney?
Yes, Your Honor.
Are you satisfied with your advice, with his advice and confidence in this matter?
Yeah.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Has anyone threatened you to make you plead guilty to the charge?
No.
Now, on page 2, about 2/3 of the way down, there's a couple of 2.5 sentences printed in bold, underlined, which are read as follows. Defendant shall enter a plea of guilty to the Bill of Information. State and defense jointly recommend 12 months incarceration. Defendant shall be designated a Tier 2 registered sex offender. Is that your understanding of the agreement?
Yes, Your Honor.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, Your Honor.
Now, under the law, Mr. Pennington, the matter sentence is up to the judge. And so even though there's an agreement between the parties that this is the sentence, the 12 months should be the sentence, I'm not required to follow that. And under the law, I can give you any sentence that I think is appropriate between 6 and 18 months. So do you understand that?
Yes, Your Honor.
Now, do you hold any kind of license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No, Your Honor.
Right now, you have certain constitutional rights you need to understand. And first of all, I did just appoint Mr. Armentrout to represent you. And that appointment wasn't simply to work the case out, but to provide whatever defense could be available to you under the law. So if you don't want to do this, you know, you'll have an attorney. He'll continue to represent you and defend you, including a trial, if that's what you want. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to have a jury trial in this charge, in which 12 people be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence would be presented, and then that jury, they'd be instructed on the law, and then that jury would decide by unanimous verdict, meaning all 12 would have to agree on a verdict as to whether the state proved your guilt. Now, if you didn't want to plead guilty, but you didn't want to have a jury trial, you can waive in writing, which means give up, like you gave up your right for an indictment. You would give up your right to have a jury trial, but then you would have a trial to the court, or what's called a court or bench trial. And in that case, it would be the judge would be the one that would hear the evidence instead of a jury, and the judge would be the one who would apply the law and decide whether or not the state proved your guilt. Do you understand that?
Yes, Your Honor.
Under the Constitution, Mr. Pennington, you have a right to confront the witnesses against you in open court and cross-examine them through your attorney. So what that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come to court to testify on your behalf, and the same as the state. So, if you have witnesses you're not certain are going to come in voluntarily, at your request, the court will issue a subpoena. It's called a court or that's a court order, and that would force them to come to court to be able to testify on your behalf if you wanted them to, even though they didn't want to be here or be involved. And that's the same way that the witnesses are forced to come in to testify for the state against you. Do you understand that?
Yes, Your Honor.
Under the Constitution, you have privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation, and that is if there is a jury trial and you do not testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Right, now, under the Constitution, you are presumed innocent of this charge until proven guilty by the state of Ohio in every essential element. So, what that means is that the burden of proof isn't upon you to try to prove that you're not guilty. The burden is upon the state to prove that you are. In fact, under the law, you don't have to present any evidence at any time in your own defense. You may, but you're not required to. But whether you present evidence at trial or not, the burden of proof will still be on the state of Ohio to prove your guilt by proof beyond reasonable doubt on every essential element of this offense, which is the highest burden of proof known under the law. Do you understand that?
Yes, Your Honor.
Now, you haven't entered a plea of guilt of any plea yet because you just have been brought before the court this morning. However, under the law, you could enter a plea of not guilty, and a not guilty plea would deny the allegation in the charge, deny you committed any crime, and it would exercise or invoke all the rights that I've just described. Now, if you change your plea from not guilty to guilty, that is the opposite of not guilty plea. The guilty plea admits the allegation in the bill of information, admits it a crime, it's a crime, that you committed the crime. And that plea waives, gives up all of the rights that I've just described for you this morning, except your right to have an attorney. You always have a right to have an attorney no matter what your plea, but with that exception, your plea of guilty would waive or give up your right to a jury or court trial, would waive or give up your right to confront witnesses against you, cross-examine them through your attorney. You waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. It would waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It would waive or give up your presumption of innocence, because if you say you're guilty, then the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal on any alleged violations of your rights you think may have occurred up until this point in the case. Now, should I sentence you to the maximum sentence, or under other certain limited circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand that?
Yes, Your Honor.
And are you a U.S. citizen, Mr. Pennington?
Yes, sir.
And are you entering into this agreement, or did you enter into this agreement, and are you agreeing to plead guilty today voluntarily?
Yes, Your Honor.
All right.
Your Honor, if I could speak with him for about a minute.
All right. Well, guess I'm going to have to close it and recreate this. Didn't used to have to do it that way, but the changes they made on the updates changed it. All right, we're going to do another breakout session here, so just go ahead and put us on recess. Okay, we're
Ready,
back
Your
on record. Anything further before we continue?
No, Your Honor.
All right. So, Mr. Pennington, you understand that the plea of guilty would waive or give up all the rights I just described, except the right to counsel, and would subject you to immediate sentencing, which is likely to happen.
Yes, Your Honor.
Do you have any questions about the waiver of prosecution by indictment of the bill of information that brings you before the court here this morning?
No, Your Honor.
You understand that?
Yes, sir.
And you have any questions about the charge or the possible penalties?
No, sir.
You understand that?
Yes, sir.
You have any questions about the plea agreement?
No, sir.
You understand that?
Yes, sir.
You understand that the recommendation as to sentencing is not binding on the court?
Yes, sir.
You have any questions about the constitutional rights I've explained?
No, Your Honor.
You understand that?
Yes, sir.
And you also understand that if you are convicted and sentenced, that you'll be required to register as a sex offender when you're released from custody for a period of 25 years.
Yes, sir.
Do you have any questions about the plea of guilty, what it means, or what will happen if you enter that plea here this morning?
No, sir.
And again, you understand that on the misdemeanor, and again, just to make sure I understand it, on the misdemeanor, you said that the sentence you got was suspended, so you've been held on this charge. It's not any other charge in jail, is that correct?
Yes, sir.
Okay, so that is a suspended sentence, and if you come out after getting out of prison, if the court determines that you've done something that would require or result in the execution of that sentence, that would be, you know, after you're out of prison on this. You understand? You wouldn't get any credit for the time you're in prison on that charge. You understand that?
Yes, sir.
All right. Now, is there anything else you need to speak with your attorney about before we go any further?
No, Your Honor.
Do you have any questions about anything that we've talked about here this morning?
No, sir.
Then is it your decision to withdraw your not guilty plea, plead guilty to the bill of information, the 4th-degree felony, pursuant to the terms of the plea agreement that you signed on the 23rd of May and that we've just gone over here today?
Yes, Your Honor.
All right, then as to the charge which alleges that on or about the period of June 1, 2022, continuing through April 13, 2023 in Highland County, Ohio, that you being 18 years of age or older did knowingly engage in sexual conduct with V, not the spouse of the said Charles W. Pennington, said Charles W. Pennington knowing V was 13 years of age or older but less than 16 years of age, to wit 14 years of age, being reckless in that regard, in violation of section 2907.04A of Higher Revised Code, unlawful sexual conduct with a minor, a felony of the 4th degree, carrying a possible prison term between 6 and 18 months, a fine of up to $5,000, and a requirement to register as a Tier 2 sex offender under the conditions of the law for a period of 25 years once released from custody. How do you plead?
Guilty, Your Honor.
All right. Court finds that on this day in open court, defendant was advised of all of his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. Pleas accepted, ordered, filed. Defendant is found guilty of the offense. Now, Mr. King, did you inform the victim's representative that there would likely be a sentencing hearing this morning as well?
Yes, sir, Your Honor, and they indicated that they did not wish to be present.
Okay. All right, then the court will go ahead and proceed with sentencing. Anything from the state?
Only what is contained in the plea agreement, Your Honor, and as I indicated earlier, the victim's mother has approved of this agreement. Thank you.
Mr. Armentrout?
I would ask the court to follow the recommended sentence in this matter. Obviously, Charles has cooperated. He saved this matter being submitted to the grand jury. He has saved the possibility of a trial and what that would mean to a victim of having to possibly testify. We'd ask the court to consider it.
Has this offender been previously incarcerated for a felony?
Yes.
Yes, you mean does he have prior felonies? Yes, he does, Your Honor, and he served a prior prison term.
Just one?
He's got, looks like 3 prior B&E convictions from 3 different counties. I think he served a prison term in each case, but I'm not, since we didn't go through the formal discovery process, I'm not 100% certain of that.
How many times have you been to prison, Mr. Pennington?
Twice, Your Honor. One from your court and one from Fayette and Clayton County Court did. They ran theirs concurrent.
All right, anything that you would like to say, Mr. Pennington?
No, Your Honor.
Well, the affidavit that was filed in support of the bind-over indicates at the time in April that this young girl was 14 years of age. It indicated she'd had sexual intercourse with Mr. Pennington 13 times. She apparently indicated that it had been done forcibly, but Mr. Pennington's statement was that although he initially denied it, later admitted and indicated it was a consensual relationship. Though it appears this thing went on for a long period of time, over a year, well, almost a year, 10 months it looks like. All right, when was the date of arrest?
He was arrested on April 12th, Your Honor.
All right. All right. It's a judgment order of the court that you be and are hereby sentenced to the Correction Reception Center in Ohio for a period of 17 months. You'll be given credit for 45 days against that sentence. Now, upon completion of this sentence, Mr. Pennington, it is required that you be put under post-release control supervision for a period of 5 full years under the supervision of a parole officer in a term set by the parole authority. If during that period of time they determine that you have failed to comply, then you will be subject to being returned for a period of up to half of the prison term, or 8.5 months for one or more violations. However, should you be convicted of a felony while under post-release control, then in addition, whatever sentence a judge in the new case can impose upon you, a judge is also authorized to sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time's left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence of the new case. It's also ordered, you're also ordered.
There's a video of the girl, there's a video from the jail out here where they set up a video where she said I didn't do none of this to her. Like she says I'm innocent.
Wait a minute, you pled guilty, so, you know, that's not an issue. You've entered a plea of guilty. You be quiet. I am sentencing you. You have pled guilty, and you're being sentenced. You've already been sentenced, and I'm just explaining to you what can happen in addition to what the sentence is. You be quiet, or I'm going to hold you in contempt. And if I hold you in contempt, then the 45 days, not all that's going to go on your sentence. All right. Now, you're ordered to pay the court costs, which judgment, grant, and execution is ordered, and if you fail to do that, then the court clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then once you complete your prison term, you can do community service in this county and be given credit for each hour you worked and an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, because of the interruption, I'm not certain where I was, but I believe I was explaining. I know I don't think I'd finished the explanation, so I'm going to go back and cover it again. You'll be under 5 years of post-release control supervision by a parole officer under the conditions set by the APA. If you violate those, they can return you to prison for up to half of your prison term for one or more violations. But if you get convicted of a new felony, then in addition, whatever sentence a judge in a new case can impose upon you, the judge can also sentence you to an additional period of a year, whatever time's left on that 5 years of post-release control, whichever is greater, for committing that offense while under post-release control in this case. Now, you are hereby designated as a Tier 2 sex offender, child victim offender registered. That means that you'll be required to register for a period of 25 years. You will be required to register in person with the sheriff of the county in which you establish residence within 3 days of coming into that county, or if you're going to be there temporarily for more than 3 days. And so since you're a resident of Highland County, your expected residence would be to be registered with the sheriff at 130 Homestead in Avenue in Hillsborough. But if that's not your residence, then whatever county you go into, you'll be required to register within 3 days with the sheriff of that county. Now, you're also required to register with any county sheriff where you may establish a place of education, doing any kind of job training, educational programming, or similar type of activity. If you are employed in a county for more than 3 days consecutively, or 14 days total in a calendar year, you're required to also register in that county. So you could be subject to registering in 3 counties at once: where you're living, where you're going to educational programming, or where you are working. Now, employment also does include any volunteer service or community service you may be doing as a result of any sentence. You're required to provide the sheriff temporary lodging information, including the address and length of stay, if you're going to be absent from your county of residence for more than 7 days, or 7 days or more. Now, after initial registration, you're required to periodically verify your residence, address, place of employment, and/or place of education in person at the county sheriff's office or offices, depending on how many counties you are required to register in, no earlier than 10 days before your verification date. Your verification date is every 180 days for 25 years. And again, you have to do that in person. Now, if you change your residence, place of employment, or place of education, you must provide written notice of that change to the sheriff of the counties that you have were registered in, and then to the sheriff of the counties that you intend to either move to reside or establish a place of employment or place of education, at least 20 days prior to a change for education and residence, no later than 3 days after change of employment, because you can be employed in another county for 3 days before you have to register there. If at any time you should not have a fixed address, then you're required to provide detailed description of the place or places you intend to stay, and no later than the first business day immediately following the day you obtain a fixed address, you must register with the sheriff that address. If you go to another state, you're also required to register in person with the sheriff of that county in that state, or whatever public official is charged with the responsibility of maintaining sex offender registry. You're also required under federal law to report any proposed international travel to your registering authorities at least 21 days prior to that travel. Failure to do so can subject you to a criminal prosecution under federal and state law. You shall provide written notice within 3 days of any change in your vehicle information, email addresses, internet identifiers, or telephone numbers registered to or used by you to the sheriff with whom you have most recently registered. All right. Now, this will be sent out to the jail for you to sign to acknowledge that you've received this explanation. All right. Is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, you're remanded to custody, Mr. Pennington.